Welcome back, everybody. We just took a 5-minute recess to take care of some technicals, but we are on our agenda for December 17th, and we are down to action items. We have got Resolution 146, setting a title of a charter amendment to Aspen Home Rule Charter submitted by petitioners. You introducing this, Jim?
Yes, Mr. Mayor, I will introduce this item before you. Is Resolution 146, which sets the title of the charter amendment to Home Rule Charter that was submitted by specifically Peter Paulson, Barb Pitchford, Helen Palmer, David Elgart, and Stephen Ornowski. These petitions were submitted pursuant to CR 210 1A1 as a charter amendment. And I want to emphasize something here, and it was mentioned by, I forgot her name is, whoever the man we had such trouble hearing from. Martha. Tiernan, that's it. Ms. Tiernan mentioned that this is being presented, these charter amendments, and the second charter amendment is also the same, is being submitted pursuant to Article 20, Section 6 of the Colorado Constitution. These are charter amendments. They're controlled by Article, not Article 5, as mentioned in a letter from a gentleman to council today. And Article 20 sets forth direction to the legislature to adopt procedures for how charter amendments are considered by the city and placed on the ballot, either by the city itself or by petitioner signatures. And only 5% of the registered electors at the time of the submission of the petition required in order to put an item on the ballot. The clerk was presented these signatures on December 9th, and she certified she certified it on December 9th, that they were submitted to the clerk as required by Section 31.210.3. Now, in the memo that the memo has a typo. It's an insignificant typo. It refers to Section 310. It should refer to Section 210. Resolutions itself are accurate. The clerk did certify the signatures for Resolution 146, or the charter amendment that's set forth therein. And Council Nelma said ballot title. I would again note that saying the ballot title is mandatory once the clerk certifies that the petitions are sufficient. There's no provisions within the statute regarding anything other than a statement that once she determines they're sufficient, the governing body shall set the ballot title. Resolution 146 in this instance sets that ballot title, and it sets forth for the voters to consider the entire amendment to Section 15.4 with strikeouts and additions set forth in all caps. We feel the ballot title and this before our election in March is quite clear and should be presented to the voters as set forth in Resolution 146. Again, just for the record, this does two significant things with regard to the charter, and specifically amending Section 13.4. It's titled Restrictions on the Sale and Change of Property. Particularly, it affects the election percentage required for adoption of any change in use or conveyance of a property. It creates a supermajority requirement of 60% of the electorate. It also mandates that the election should be conducted with regard to an action under Section 13.4 conducted on part of a statewide general election held on the first Tuesday succeeding the first Monday in November in each even-numbered year, or part of the general municipal election held on the first Tuesday of March in each odd year. So it's only in general elections, not in special elections. So that's the gist of the changes. It's set forth very clearly. We believe this can be placed on the ballot pursuant to the ballot title requirements and will be easily determined. It's not confusing. It's fairly straightforward as to what is proposed to be amended. And it requires a yes vote. It means you support this. A no vote, that means you oppose it. And that's something to recognize on the record because there's requirements that not be confusing. So, and in the past, there have been elections where yes, no and no means yes, and because of how it's worded. This one's very clear, very straightforward, and it would, if passed, change Section 13.4 as I just outlined. I'm happy to answer any questions.
Sam? Bill? Done.
Sweet. Thank you. So this is our first citizen-driven ballot question. I just wanted to ask you a question about the formality of this all. And it's interesting to me that citizens put together a ballot question and it comes to us to approve or deny it, but threshold. So that is I'm sure 99% of the time this is a rubber stamp, but I sort of wanted to ask you if you can answer, is there any precedent to A, rejecting these, or B, like what councils have done in the past to change the title? And like, I can't even think of like objections they would have of something that hundreds of citizens signed.
Well, as I have said earlier, that the statute, once it's deemed certain, statute mandates setting a ballot title. There's some leeway in what the ballot title can say that council can exercise, some discretion, but it does not have discretion in the statute to not set a ballot title and place this on a ballot. And I am not of any circumstance in which a council has been faced with this kind of charter amendment in which it has rejected the charter amendment despite the certification by the clerk. In fact, there are cases that we have found that in the state of Colorado that have rejected charter amendments in this circumstance. Yeah. It's something that the citizens signed, and council should set a ballot title and place it on the ballot.
Yeah. And this is purely for education purposes, and I'm trying to be so silly here, but I'm very curious. City council put on this ballot question or another ballot question, so I'm not being serious. And other than asking the question, be like, here's the ballot question. You could be like, in the ballot question, vote for this one or something like that.
That would be inappropriate.
But like, is it?
The statute does have obligations about having a title that advocates a particular position or creates that confusion that I'm talking about. Because you can set a title that is worded so in such a convoluted way that, and we've seen this in the past, yes means no and no means yes, depending on how, I can't put forth that example of that, but it has been done. That would be inappropriate, and we would invite courts to step in and say, no, this is an inappropriate ballot title. Yeah. This is not that. This, in my opinion, complies with the obligations of the city to set the title in a straightforward way that clearly set forth what is intended and what the amendment is.
Yeah, I'm really just trying to understand what our peer review is here, where I don't know anyone would have any objection as far as like I want to change this word or I want to change that phrase or something like that. But this was put together by the citizens, so
yeah. You have some leeway, but it's very minimal. There's an argument that your action is really strictly ministerial. You're just taking what the citizens proposed to you, and as you said, rubber stamping it. It's a ministerial act, and you're setting a title to put this in front of the voters. And you know, because it's a slight bit of leeway and discretion. I hate to use the term of ministerial, but that does come to mind.
I appreciate you saying that because that's really what I was getting after. Like I said, this is the first time I've done this. It's a big education for me. And, it's like interesting to have this feeling of contention over a citizen-initiated ballot. So the
last one the City Council faced was what we call Ref 1, which is 13.14, in addition to the charter involving use actions and limitations on variations and certainly in use matters in certain zone districts in certain areas. And I can't remember, it was done 2015, I believe.
It's been a while. Yeah. Okay. That's all I have. Thank you.
Jim, on this one, this is 146, the first one, right?
Yeah.
Well, I guess that applies to both, but the ballot title that we are discussing is just the section in caps before the paragraph that says shall section 13.4 ... right?
Well, that's a good question. The ballot title can be more comprehensive. It's a section in the statute. The statute sets forth a section that says the title is here. And, you know, is it the entire thing, is that considered the title, or is it just that section you stated? And that's a little unclear in the statute. But what you're trying to do that for the community, a clear statement of what you're voting on. Because if you just read regarding restriction on sale or exchange and use of parts in open space, that didn't tell you that. So what we're trying to do and we're trying to convey to the electorate is a more definitive statement. Now often, and what you can be thinking about is often if it's going, and Ref 1 may be an example of this, it was long, but it also referred to an ordinance. The ordinance set forth what the election was about, and that's done. You have something similar to that language, and you set forth in Ordinance 13. But this is a petition situation, it's not an ordinance that you can refer to. So that's why theoretically the whole thing could be considered a title. You're right, what's generally done is and again, it gets very confusing because there's so many different sections of the Constitution. This type of concept is the title limiter, and that's the all caps, and that's a table requirement for titles and for ballot issues on text matters, and you have to set forth all that in caps and such. So it goes very a lot further when you're dealing with table things about as long. It can often be as long as this one is. But, you know, that was a long-winded answer. I am really asserting that this is all kind of the title.
I'm not sure I got clarity from that. Thank you, Jim. So the section in caps that I think is what we're supposed to be focusing on for the most part, correct me if I'm wrong, but I think that what you said was that's really where we should be focused, but everything's kind of up for grabs.
Well, to the extent that where your leeway may exist, that IB is right there. If that's your question, I would agree.
I think that's right, because I think the following part came from the section itself,
Yes.
right? Okay, so where did the section in caps come?
That came probably from the,
So what I'm specific, to be totally clear, I'm talking about City of Aspen referendum number 1 through open space, the last 2 words.
I'm trying to remember if that was actually set forth itself in the petition, or if that was a,
I doubt it, because how they know to call it referendum number 1?
well, the referendum number blank would have been set forth. I will tell you this, that I did review this language, or did present this language to the proponents of the referendum, and it was, in fact, I think they requested us like change that title. So this title came from me. I'm thinking this through. This came from me.
Thank you. That's what I thought you were going to say, but I wanted to make sure.
Yeah, but they did request a change, and I thought the change was appropriate. Because you look at the title of 13.4 where it says restriction on the sale or change in use of property. The amendment really is changing use of parks and open space. So there was a slight change in that language that I had initially proposed. But you're right. And that's where the leeway.
All right, and sorry to interrupt you. The leeway they're talking about is something that might be appropriate would be in the sentence that says amendment of section 13.4 of this charter regarding restrictions. If I suggested putting the word enhanced before restrictions, would that be appropriate in terms of, is that the kind of leeway that you're talking about?
I think-
Just trying to get context here.
No, I think that would be within the consistency of your discretion on the title.
Thanks. And I know Sam already asked this question, but I want to ask it in a different way. When I get voting materials for securities, there's often a board of directors recommendation, a guidance on how to vote. That any notion of that is in this context?
Well, you have a right to pass a resolution supporting or opposing any ballot issue. You can't spend money and to advocate it, but you have a right as a council to pass a resolution supporting or opposing either one of these. It's just within your authority to do it, and it more consistently on state issues. And that's quite common for a city council. You have the right to do it on your own issue. It came up consideration, I believe, on the airport issues. And I believe you guys chose not to do it, but
We did.
you did.
So,
And could the results of that resolution,
That would not be appropriate.
so even though you said you could reference an ordinance, you could not reference a resolution?
Well, no, it's different. When I'm saying reference the ordinance, it's the ordinance that's proposing a change. For instance, in LIF 1 for ballot issues, it specifically referred to Ordinance 28 and Ordinance 29 that approved the two projects. And it was that reference told the voters what you were approving, which was those two ordinances. That's a different thing than trying to put a resolution supporting it onto the ballot. That
Okay,
would
great.
not be appropriate.
So in other words, this resolution have to be totally separate on setting the ballot type?
Correct. And it can be done anytime prior to the election.
Thanks, I'm done with questions.
Thank you. John, I think you're next.
my questions have been answered.
Any further?
Yeah, Bill, just for a little maybe clarity, what Jim said didn't make it very clear to me either, but the instance where city council supported a ballot issue was 1C. 1C was put on by the Board of County Commissioners. 200 was put on through a similar thing, a referendum. It was, petitions were gathered, and so both BOCC put resolution 200 on the ballot because they were in the same circumstance where it was a citizen petition. It met the threshold, and they put it on the ballot. 1C was perhaps a reaction to it, but both of them got on the ballot, and then city council weighed in on 1C and perhaps a 1A, but 1C anyway. But it is just the point to give the people the choice. And so my comments are the same for 146 basically as they are for 147. Is that I may not agree with 146, and I probably won't vote for it, but I support the people that the right of and encourage people to bring forward petitions to express their heartfelt views. And Bill, you attempted to petition to overturn an ordinance. I've been involved now, this is my third petition, but I have a couple, this is the first one for a home rule charter, but, in my case, and I think perhaps in your case, there was something that, went on that got you engaged, and you were engaged to the point where you were on council now. I know John Doyle was upset with 1C, and was very active, or, the, 1A, and tried to overturn it, and came, darn near did overturn it, but that led him to be on council because his interests were perked. Same with me. I was engaged in, this is something that, there's something that get people engaged in the process, and so it's a good thing. So maybe Barb is gonna run for city council next time. But
They're still available.
it's a democratic process, and what we're doing is we're just giving the people a chance to vote. And once it's on the ballot, then it's wide open. We can debate until the election in March, but this is just to give people a chance to vote, and I think we basically are told we have to do it, but this is as good a time as any to give you another Jefferson quote. I used this once before. He said, a democracy is nothing more than mob rule, where 51% of the people may take away the rights of the other 49%. And in 146, it's 60% plus one, but it's a democratic process, and I support it. May not vote for it. I won't vote for it, and I may write a letter in opposition. But I think in our case, as individuals, we can do anything we want, but we can't do it as citing that we're members of city council. We can have individual stances on anything. So I certainly support putting this, giving this to the electorate to make a decision, and I think we have an informed electorate. And I'll throw this one into another Jefferson quote: "The government you elect is the government you deserve." So it's just important to democracy. So I'm going to support this.
I'll make a motion to approve resolution.
Said a thing.
Oh, sorry.
Thanks, John. I'm just going to make a couple quick comments. I think that well, first of all, question. Charter changes only have to pass by a simple majority?
Correct.
Yeah, that's a shame. It'd be great if this had passed with a 60% majority. That would be awesome. And the same for the other one. I think charter changes should take a greater threshold. I think that both this one and the next one that we're going to discuss are a little bit of backdooring the democratic process. And, this one, for example, if this was started in a year where we weren't talking about uses for entrance to Aspen, and this was just about protecting open space or something to that degree, I'd be like, that's great. But this is actually to prevent something, not enhance something. And so to me, it's a little bit of a bummer. As I said earlier in the meeting, I don't think you guys were here yet, but this city council embarked 4 years ago on the entrance to Aspen as a community dialogue, trying to get to a solution that our community could get behind. And so then these two petitions pop up, and it's I felt like this council, both councils, the previous one and this one, doing our best to really do a community process. And then this petition comes up, and then the next petition comes up, and I'm sad at the fact that this is how democratic process is being used. I have further comment for the next one that we're gonna talk about, but we talk about an informed electorate. On this issue, we're not. I'll give you an example. We even have depictions and descriptions of different alternatives that are not even detailed, not even finalized, not even correct. So I don't think people really know kind of what their opportunities and options are. As we talk about this, somebody earlier made a comparison between this and the airport as an issue. The only real kind of similarity I can find is that going into this election season, the same kind of fear and intimidation by outcome that was used at the airport might be being used in this issue. Not this referendum, not the next one, but this issue. And it's a bummer for me. I was really so proud of these last two councils that had the balls to come up and take on the entrance to Aspen and engage our community. And then it's kind of being usurped, and it's just a shame to me. But I'm not going to prevent this or vote no against it on the ballot. I think they fulfilled all the provisions that they need to. And if the language is what they want on the ballot, then it's met the requirements. So those are my comments.
I'll make a motion to approve resolution 146, series of 24.
Seconded.
We have a motion in for further discussion.
Thank you. I appreciate all, and I agree with the large majority said, Tori. I think it's important to acknowledge that there's a lot of concern here on both sides of the argument, and it's understandable. And I agree with you that if this was proposed without the impetus of the entrance to Aspen, it would feel really good. I think it's a really good amendment. And so I encourage everyone to, as we move towards the March election, contemplate how this would be a good thing regardless of the impetus being the entrance to Aspen conversation. Given that parks and open space are my most treasured assets of this community, and I think many of our residents share that sentiment. So again, my request of everyone to think about over the next several months is this important to you regardless of the impetus? Is this amendment to our charter, given how treasured and important our parks and space are? Let's not let the impetus ruin what is a smart and important virtue of our community. So I'm super supportive of this one, and I think the community for all their efforts bringing this to us for our opportunity to weigh in on.
We have a motion. Any further discussion? Could we have a roll call vote, please, on Resolution 146?
Counselor Doyle.
Yes.
Counselor Guth.
Yes.
Counselor Howenstein.
Yes.
Counselor Rose.
Yes.
Mayor Tory.
Yes. Our next item is resolution number 147.
Mr. Mayor, I'm a little concerned about the fact that I did not clarify and messaging clearly, and I'm rethinking it. And I think what you have really hit on is within the title, where is their discretion, like it is in that position that's all out. Because the rest is what was set forth by the petitioners and what was signed by registered voters. So if there's any discretion, it would be in that section, all caps. I do think the way the statute's written, 31 to 210, 220, I believe, one of those, it really designates the whole thing as just a recognition of the nature of the statute.
Tori, can I respectfully ask that Jim weigh in on Ward's recusal from the petitioner on it?
Yeah, of course.
Thanks.
This was anticipated, didn't come by a citizen asking a question. I've talked to Ward about it. And tonight I'm going to weigh in on Rachel's question about your participation, which I think are I just saw an email from Rachel that something's broadcast.
We got it fixed.
Okay. Anyway,
Yeah, he didn't say anything. I know, but I'm just. He was talking about the video feed and that it got cut off.
I understand that
Yeah.
part. I'd like to hear the rest of what he's gonna say.
Yeah, so a little louder, Jim.
Into the mic.
okay.
Thanks.
I'm trying. Okay. Consider this and discuss it with other assistant city attorneys. And the key factor on both solutions really is set forth in our charter 4.7, as well as in our code. And the key language in both is whether there's a substantial personal financial interest other than the common public interest. In reviewing any of these situations, we have to look carefully at what that potential substantial personal or financial interest is, whether there is a common public interest that someone is perhaps advocating or voting on. And in this situation, it's hard to define in any of these situations that have arisen over these subjects where that substantial personal financial interest is different than what is otherwise the authority of a council member who is considering these issues to consider what's in common public interest. And that is the language in the charter, common public interest. So what we have concluded is that in neither situation is there a basis in which someone is mandated to recuse himself here. It only may be something someone wishes to do. But in any type of situation, which is in essence either this ministerial type act to put something on the ballot or a legislative act, council members are free to make whatever judgments they wish to make and to advocate those positions. And that's clearly within the authority. Prejudgment, which is often used to assert that there's a conflict or whatever, is not a factor other than in a quasi-judicial proceeding, and that's not this. So again, a long explanation, because we tried to look at it very carefully, is that no party on council right now, I believe, would be violating any provision of the charter or the code, participating in these things, or otherwise facing a mandatory recusal. And if you're sitting at this table, but you are mandated to vote, either yes or no, you are not allowed to abstain. So that is the one mandatory aspect that has to be emphasized. If you're sitting at the table and mandated to vote, we do not have an abstention procedure. So since there's no violation of our codes that in my opinion, whether it's the code or the charter, I do not see any necessary recusal.
Thanks. And there's no Colorado case law specifically pertaining to someone who's a petitioner on a charter amendment?
Not that we've seen. No, certainly not. I mean, charter amendments are, and courts tend to believe that when they're signatories by the citizens for a proposal such as this, it is up to the citizens to vote. and having that in front of the citizens now is the appropriate procedure. But I can tell you, I've not seen any case that would say that it would be improper for somebody who signed the petition to vote on putting it on the ballot once signatures were obtained.
Thank you.
Our next item is 147.
Yes. And that was kind of the lead-in as to the participation by everyone on this item. And it's also submitted by citizens. The clerk certified the signatures in short of December 11th or something. The statutory requirement is the local public body shall set the ballot title at its next regular meeting. This is that meeting. This is the proposed ballot title, and in this language, in that first all cap section, it was the language that was suggested by the city attorney's office. Me. That being me.
All right. Is there any,
I will just say on the record, I did off the petition signatories, at least Ms. Richards, an opportunity to weigh in on this, just as I did at 146 with the representatives of that group.
thank you. Any questions, comments at this time?
No, I just wanted to comment about the email we got from a lawyer for this group, and without breaking confidentiality, I just was wondering if you could open a response without breaking confidentiality on it. Just
Well, I don't want to disclose and discuss my confidential memo. I will say one thing, is that Ms. Tiernan did express my position with regard to this, so she made a public comment, but I disagree with the assertions. They're now part of the record of the attorney. This is controlled by, as I said earlier, by Article 20, Section 6 of the Constitution. It is not an initiative and referendum that is subject to the Wagner case or Article 5 of the Constitution and our charter, which discusses referendums and initiatives that are associated with ordinances. This is a charter amendment. As a charter amendment, the statute says the Constitution says very clearly that's reserved the members of the electorate, and they may amend and add to it at any time. It is the statement of the Constitution that home rule charters are created to govern the community, and that all the powers that are available to the community are available to the citizens to place in the chart. And that's what this is doing.
I got Bill and Ward.
Yeah, a couple of things. I've never heard of this. Mark Gruski, an attorney who sent us all that email the other day. I looked him up, and he seems to be an extraordinarily accomplished campaign and election attorney in Colorado. Whatever Campaigns and Election magazine is, called him Colorado's best election lawyer, Barton. He was awarded top lawyer in Colorado by Law Week Colorado in 2009, 2012, 2014. So, needless to say, I think this person has quality, and I'm torn between the advice of, which I value tremendously, and I found to be reliable, and Mark Skin's opinions on this. And as such, I wanted to suggest a concept to make sure that we are getting this right, of having the city ask the district court for a declaratory judgment about what's appropriate here and what not, because I just don't feel comfortable one way or another about whether this is really just an administrative question cloaked in a Dodger, or I'm sorry, in a charter amendment or not. And so I'd like to suggest that section for discussion.
If I may, there is no case that supports the position that he asserted. Title 20, or Article 20 of the Constitution is quite clear. He did not address it. That's all I wish to say. I don't really want to get into an argument with him here. If he has beliefs that the clerk did not follow the certification properly, then that's up to him.
Can you please tell us, we have a council member who is asked for consideration, it'd be followed by a motion, but before that, can you just describe to us what Bill's suggestion entails?
Well, the declaratory judgment action, which in an email he provided, went out an action that the city of Aurora, I believe, took, where they had, similar to our Wagner case, they had a situation where a party was asserting, trying to refer an ordinance that was passed by that city. And the city believed that petition was inappropriate as it went into an administrative action, which is basically the Wagner case. And so rather than go through the processes that we went through with Wagner. They went to court and just got a declaratory judgment, and no, this is administrative action. Court held it was administrative action. But that was an attempt to refer an ordinance. This is not that. This is not an attempt to refer an ordinance. This is not a referendum. It's not an initiative under Article 5. It's a pure amendment under Article 9. And no case has suggested, and there have been many cases that have addressed charter amendments involved in administrative actions, and I outlined some of those in my memo. You know, you would have a right to do a declaratory judgment under the situation. I do not think it's necessary.
What is the timeframe that something like that takes? We have to approve this for ballot by January 7th, I believe.
Correct. You could not get I do not believe you could get a ruling under this circumstance in that time period.
Yep. Okay.
You know, where I'm struggling is you've got this, what seems to be a very prestigious attorney who I also presume understands the difference between Article 5 and Article 20.
Well, you didn't mention it. Sorry.
If this was someone from a different state or someone who didn't seem specialized specifically in this type of thing in our state, I'd be more concerned. But I would assume this person knows what they're talking about. And I don't think for a few hours of fee, they would stake their reputation making assertions that something like this is inappropriate if they didn't genuinely believe it was inappropriate. My conversations with not Mark directly, but someone who has spoken with them, is that a declaratory judgment it could be a relatively quick process. And you know, if we decide to take a declaratory judgment, we still have to set the ballot title?
I believe right now this is a ministerial action. You don't have to do it tonight, but you have until January 7th to set that. But I do believe you are at this time pursuant to Article 20 and Title Section 31.2.10 mandated to set it. Again, you do not have to do it tonight.
Understood. Thank you. Board, if you have some input or questions here, that'd be great, but I don't think that we should get into debating that without a motion. So if you want to add some color, that's great.
Yeah, I have the right to express my beliefs just as Bill has the right to express his. He wants to drive a line. I think that it's hypocritical to approve 146 and then object to 147. I think that any good attorney, as any good debater, can make a real solid case for either side of the issue. So the fact that this attorney has a good reputation, perhaps this is why Neil hired him to opine on the subject. And that if we as a city council were to follow every person that hires an attorney to write an opinion in support of their position, then we're not doing our duty to represent the people. So I think that, you know, I don't begrudge you for bringing this up, but I just don't think it's valid. And I know that the first email I got with a City of Aspen email account was that I was being sued individually and the council and body to try to get what this person wanted through the courts. And if we, as a council, are going to be persuaded by what some hired attorney presents, perhaps a persuasive argument, then we're not doing our duty here. And our duty here is to represent the people based upon thousands of pages and hundreds of hours that we attend meetings and read packet. And I think our duty here tonight is to give the people an opportunity to vote on this. And if we put it on the ballot and the people that oppose this want to take legal action, that's their alternative and that's their option. But I don't think that we should undermine this effort at this point.
Thank you. John?
Just based on what Jim's told us, it seems like we're obligated to put the Friends of Meralt question on the ballot. We're obligated to put this on the ballot. Let's put it on the ballot.
Thank you very much. Did you have any further questions or discussion? Almost times I've been during discussion. I'm going to reiterate what I said on the last one. You know, again, and I'm not taking sides on either one of these. I just think it's a disappointment that as this house has been in a public process and a community-involved process for the entrance to Aspen and making improvements there, that these citizen groups be egocentric and selfishly pursuing what they want and utilizing, again, like I said, to me it feels like it's just it's manipulating the democratic process. It's not an informed electorate, especially when you have less than 50% of your registered voters turning out for some elections. We'll see how this one goes. We are trying, as a council, we are trying to get to a solution on this entrance to Aspen that is the best interest of the community, and that means a lot of different varying factors for a lot of different people. And I I think as this moves towards the election, there's going to be some great debate and discussion. The problem is like I said, in campaigns, it's not always open, honest dialogue. It's oftentimes one-sided, waging for an individual point of view, and that's probably what this is going to devolve to as well. Again, I'm disappointed. I really think there's a better way for us to all go about it. For everybody that is saying, "Oh, we want to make a decision. It's time. We need to once and all vote for this." Well, the record of decision is 30 years old, and it deserves reevaluation no matter what we do. But more than that, this community deserves to have the alternatives explored and be able to go with a partnership with CDOT, VI.A, or whoever else is involved, and not this adversarial contention that we are dealing with in this community. It's a disappointment to me. The problem and the biggest issue I have with 147 that we're talking about right now is that it is clearly defined. It is turning over well, first of all, let me just say, CDOT is on their own program. We just got a bridge inspection that told us that this is good for another couple cycles. That's like 5-6 years before they're even like considering any repair or upkeep maintenance that they think is going to be necessary. The second thing is CDOT's already stated to us that they have a question themselves about what is necessary from the city of Aspen voters in order to approve them doing what they want to do. But the main thing is that we have engaged them and they are willing to be at the table with us as we work through an EIS process to get to something that really suits this community. 147 doesn't delineate that. There are people out there that can support some usage of rural open space or other open space for other uses. There are people out there, but this question does not allow them to make that choice. This question kind of gives them, a yes or no. I said earlier that I'd say this is kind of akin to me for the Lift 1A question. The Lift 1A question was poorly formulated. It should have gone to the voters in the shape that it was. And this to me is kind of the same thing. So I'm sad, but I'm, again, doing my job at this table. I think that from what I've gotten, I think we need to place this on the ballot as we did 146. So.
May I have one final word? I think that both of these initiatives are going to have plenty of time. All of the sides are going to be presented, and our voters will decide on them.
Yeah. So I'll maintain the last word and say, I'll take a motion now.
Counselor Doyle?
I move that we adopt Resolution
Oh, sorry.
147.
I'll second.
We have a motion and a second. Further discussion for Bill.
Yeah, Jim talked about how we had to have clarity in the ballot title. And I keep rereading what we've identified as the dominant title section. It's not really clear to me what ultimately is being asked, and you've alluded to that several times. So what I would like to suggest is perhaps we enhance the language in this title to clarify that.
Well, you know what, we've got a motion and a second on the table, so if you're formulating friendly amendment type stuff.
What I am formulating, thank you. So I'd like to propose is some enhanced language in this ballot title. Right now it says allows the Colorado Department of Transportation's utilization of portions of Marlton Thomas properties identified in the 1998 entrance to Aspen record of decision. I think something along the line of in order to construct the 1998 entrance to Aspen record of decision might be more appropriate.
As a mover of I don't accept it as a friendly amendment, and I will point out the last paragraph of this question says that any future EIS are preferred alternatives arrived at through the process. So this is not nailing down any one, the whole EIS. Bill, you weren't here last night, and I hope that your daughter's play went well, but we did have a discussion with about what the process for the EIS is, stakeholder involved. I won't go into all of that now, but just that there's a time and a place, and we don't even know that the CDOT and VI.A is going to open the EIS. But as this plays out, we'll have ample opportunity to express our, and be as persuasive as possible, but I don't accept that as a friendly amendment.
Consider it an unfriendly.
And certainly move to amend, and
I move to amend the motion to include language instead of identified in the 1998 entrance. I would propose in order to construct the 1998 entrance to Aspen record of decision or any future record of decision. And any future record of decision, I guess that's the correct terminology.
Jim, retracting that
I am.
on for size.
Yeah, I had noted the possible inclusion of any future decision in that title, but your first part was identified. Can you say that again?
Yeah, instead of the word identified,
Yeah.
I would replace it with, I would strike out identified in, I would replace it with construct.
To construct.
Yeah, and then after record of decision, or I don't know where you most appropriate, the 1998 entrance to record of decision, or any future record decision.
I think the any future record of decision actually is, I would recommend, to council, I don't have any opinion on that.
Is there a second to my motion?
Then, if there's no second, I would suggest to move in the second to add that or any future record of decision. Then it's an amendment. I think that's in the last paragraph. It is, but it would just add a clarity to the title that's up at the beginning.
So you're suggesting that any future record of decision, because it's already in the ordinance, it's already in the last paragraph.
It is, but we just added, it's just a suggestion added in the title to make it clear. It's,
If,
I was okay with the title as it was, it's up to you, but I could see that clarity.
if you think it makes more clear, I think the last paragraph clearly states that,
Yeah, it does.
so.
I'll tell you, I had this question about it when I first read it and stuff. So if you can consider it, I'd love you to consider that moving that up to the beginning, because, and I think I talked to you about it, but I talked to Jim as well. The language that's in it it breaks it out into two, because the top line reaffirms the preferred alternative, and it's not until later in that it says or other future approvals. So I would love you.
I would accept that if for clarity, because it already states that in the second paragraph of the ballot issue, but for clarity, I don't object to that.
I appreciate it, because that was a question that I had early on. It does say it later, as you state, but it was kind of funky how it was written, and it was of concern, but that would clear it up.
If it's acceptable to John as a seconder.
I think if it helps clarify, I'll support it.
Jim, is that clear for you?
Yes. Yes.
Okay. So we have an amended motion and second. Any further discussion?
God, no.
Can we have a roll call vote for the last item of the calendar year?
Counselor Doyle,
Yes.
Counselor Guth,
No.
Counselor Howenstein,
Yes.
Counselor Rose,
Yes.
Mayor Tory.
I'm a yes.
Yeah. I'll make a motion to adjourn.
I'll second.
We have a motion and a second. Is there any further discussion?
Hallelujah.
Further discussions. Happy holidays to everybody. Happy New Year. Happy end of the year. And thank you as always to Grassroots. Can we have a roll call vote for adjournment, please?
Counselor Doyle.
Yes.
Counselor Guth.
Yes.
Counselor Howenstein.
Yes.
Counselor Rose.
Yeah.
Mayor Tory.
Yes. Thank you, Grassroots. Have a wonderful December. We'll see you in January. See you next year.